You're watching The Legal Breakdown. So we are just days away from the jury deliberating in Donald Trump's New York criminal trial, so I really want to get into what happens in that deliberation room. So Glenn and I are going to dive into that since it's especially timely right now. But first, just a reminder that we're going to be doing daily breaking coverage of this trial, so if you want to follow along with what happens, please make sure to subscribe. All right, so Glenn, let's say the defense and the prosecutors both rest, closing arguments, rebuttal, final word from prosecutors, then the jury deliberates. So talk about what happens in that room, because this whole process feels like a bit of a black hole for most of us.
And it's designed to be a black hole. Very rarely do we get to pierce the veil of jury secrecy. That's a term of art. The sanctity and the privacy of jury deliberations can almost never be violated. There are a few exceptions, which we can talk about in a few minutes. I will say, for all the years that I was a prosecutor trying cases, I never was called for jury service. I wish I had been, because I would have loved to have been in that deliberation room just to see how it generally works. I get to walk into the jury deliberation room after a verdict is returned, at least in local court in D.C., not in federal court, different rules. And what I would often see made me feel a little bit like it was a scene from the movies, because I'd walk in and there would be these enormous sheets of paper from like a large easel that is provided to the jury for their use during deliberations, and they will have torn off the sheets and they will have taped them to the walls, and they will have all sorts of notations on those various sheets that obviously aided and assisted them in their deliberations. And the way I would glean a little bit of insight into how deliberations went is particularly after it was a hung jury, when they couldn't unanimously agree on a verdict, either guilty or not guilty. I would go back to the deliberation room and I would spend a long time talking with the jurors about their perception of the witnesses, of the evidence, of the defense, because what I had to do was determine whether I wanted to retry the case or perhaps just dismiss it and not take it to a retrial. And jurors would talk openly about, their perception of the evidence, what witnesses they credited, what witnesses they questioned, maybe they were a little less than credible, where the holes in the evidence were in their estimation, and maybe what I could do to try to shore up or fill those holes. And I will tell you, Brian, even when I was in there after jury deliberations had concluded and a hung jury was declared, a mistrial was declared by the judge, it would still be heated. I would see jurors arguing with one another, continuing to argue their points, whether in favor of conviction or in favor of acquittal. So often I think it does get quite heated. Interestingly, there would be times that we'd be in the courtroom while the jury was deliberating, and we would actually hear pounding on the walls. We never knew what was going on there, if somebody was making a point or if they were, fisticuffs were breaking out and they're throwing each other up against the wall. But, it does get quite heated. So I think the first thing that jurors are told to do when they retire to deliberate is to select a foreperson, somebody who can sort of facilitate the civil exchange of ideas and arguments, and that's usually the first task they have. And after that, the judge tells the jurors, you are free to deliberate however you would like. There's a standard judge instruction, instruction of the law that goes something like, you are encouraged not to immediately take a vote when you retire to deliberate, because you may become entrenched in your position before you've ever had a chance to discuss, your view of the evidence. So you're not required to wait, but you might want to wait. So I do think some jurors abide by that instruction. I think some juries take straw polls right up front because maybe the case was really clear one way or another, and they want to take a straw poll to see if they can maybe move to a verdict very quickly. But, in my experience, jurors like to take their time going through all of the evidence that they've seen. There's kind of any number of rules of thumb. Like if a trial took a week, a jury might take a day to go through the evidence. If it took 2 weeks, they might take 2 days. I've tried as many cases as most people, and I would say that's probably a pretty good rule of thumb. With a trial like this that lasted, in earnest, I think 5 or 6 weeks as far as the presentation of evidence, we could see the jury take several days to go through the evidence, but we could also see them resolve it fairly quickly. What I don't think we're going to see, Brian, is an acquittal, a not guilty verdict. Why do I say that? I think the prosecution presented a really compelling professional case on the evidence. So I am hard-pressed to see all 12 jurors saying, no crime here by Donald Trump, or the evidence failed to prove Donald Trump's guilt beyond a reasonable doubt on all 34 charges. I find that very unlikely. Now, a hung jury, you can always have a hung jury. It only takes one. My assessment of the evidence, and if there's one thing I know over my 30 years as a prosecutor, it's how to assess the quality and quantity of evidence in a criminal case. I think the evidence is strong. I think the case is a common sense one because all of these crimes were committed for the benefit of Donald Trump, indeed, according to Michael Cohen, at the direction of Donald Trump, which makes complete sense, both as a matter of common sense and as a matter of the evidence and the law. But every jury deliberates a little bit differently, and we'll just have to see when we hear anything from the jury. I do suspect the first thing we'll hear from the jury, Brian, is not a verdict. It's likely to be a note, because the other thing, in my experience, that we often see once juries go out to deliberate is they come up with questions. And there are two kinds of questions that we typically see from juries. One involves factual questions, questions of fact. Like, Your Honor, we can't quite remember what witness number 7 said about what time of day a particular thing happened. Can we get some additional clarification of that? And I can tell you, Brian, the judge will almost always respond to that note by saying, your recollection of the evidence and the facts control, and I cannot provide you any guidance on matters of fact. But then they may say, you know what, Judge, we have a question about a legal principle. Like, you gave us a definition of what proof beyond a reasonable doubt means, but we'd like a little bit more clarification on that because we're having some disagreements. That is something that the judge will then turn to the parties, prosecutors and defense, and say, do you all have any proposed answer to the juror's question about maybe clarifying a legal principle? And that's something that judges will do frequently. They'll try to be responsive to the jury's legal questions, but they will never respond in substance to the jury's factual questions.
Glenn, I feel like it's common knowledge that a shorter deliberation means a higher likelihood that the defendant is guilty. But is there a cutoff, I guess in this trial specifically, where you feel like a deliberation going past a certain length of time suggests that a guilty verdict isn't likely? I'm trying to give us some information, to arm us with some information so that while they're deliberating, we have a better idea of what to look out for if something happens soon versus something happens later.
Yeah, Brian, you're absolutely right in your assessment that a quick verdict is typically a good verdict for the prosecution. There's a reason for that. When you think about what it takes to get a case to trial, you've had, after the crime was committed, a police investigation. Then the prosecutors will often get involved in the investigation. Then we'll present all the evidence to the grand jury, and the grand jury will make an assessment about whether there's enough to indict the defendant. Once the defendant is indicted, he or she will be presented in court, and there's all sorts of pretrial proceedings in the run-up to the trial where defendants will, for example, make motions to dismiss for any number of reasons, make motions to suppress evidence. And the case has been vetted through lots of people and lots of processes in the run-up to trial. And by the time the prosecution believes that the right thing to do is to present this case to 12 jurors, prosecutors are typically feeling pretty confident and comfortable that they have enough evidence to prove guilt beyond a reasonable doubt. Of course, prosecutors don't always win. We don't always convince the jury. But I think that's why the prevailing wisdom, and it has been my experience, that a quick verdict is a good verdict. Why? Because the jurors ended up seeing it the way a whole bunch of other people, both professionals and lay people like grand jurors, saw the evidence. So a quick verdict is typically a good verdict for justice, in my estimation, for the prosecution, for the victims, because it's a guilty verdict. However, there is no length of time that passes that you can point to a day or a week or 2 weeks as meaning that all hope is lost. Okay. I do think there's a point of diminishing returns. The longer a deliberation goes, the less likely you are to see a guilty verdict, with the following exception. I tried a 6-month RICO trial, for example, and there were dozens and dozens and dozens of criminal charges that had to be resolved by the jury. That's the kind of thing where they could deliberate for weeks and weeks and weeks, and we will hear nothing from them. And that doesn't mean that there's a hang-up. That doesn't mean they're unable to unanimously resolve the charges. It just means they need a lot of time to pour through the evidence. This is not really that kind of a case, but 34 felony counts and a trial that spanned 5 or 6 weeks, they could go a week and we could hear nothing, or they could return a verdict within a day or two.
Okay, well, we will obviously be here covering the entirety of that as long as the deliberation goes on. So for those watching right now, if you want to follow along with our coverage, please make sure to subscribe. The links to both of our channels are right here on the screen. Highly recommend you subscribing. Glenn is fast on his way to 1 million, so if you're not yet subscribed to his channel, please go ahead. And my channel is up to, heading on its way to 3 million, so if you're not subscribed to this channel, please subscribe as well. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.